Welcome to This Explainer. Today, we are tackling one of the absolute most fascinating puzzles in the legal world. We're going to demystify exactly how the justice system objectively defines a mistake. Think about it. When something goes wrong, how do we actually decide who is legally at fault? It's a really wild journey, and it's going to take us from the freezing winters of Victorian England all the way to modern hospital delivery rooms.
Okay, let's dive into this. Look, we all make mistakes, right? You might accidentally bump into someone on the street or, totally misjudge a turn while driving. In everyday morality, we kind of judge people by their intentions. We say things like, well, they didn't mean to do it. But the law requires a totally different framework. The legal standard for negligence can't just be about whether you're a good person who was having a bad day. It needs a completely objective yardstick. If you make a mistake, the law actually has to precisely measure your actions against a very specific benchmark to decide if you breached your duty of care.
To figure out exactly how this works, we're going to explore 5 distinct areas today. First up, the reasonable person test. Second, measuring foreseeable risk. Third, we'll get into learners, children, and exceptions. Fourth, the professional standard. And finally, the massive modern shift to informed consent.
So kicking things off with Section 1, the reasonable person test. This is the legal foundation.
This concept right here is literally the bedrock of negligence law. And it all started way back in 1856 with this case called Blythe versus Birmingham Waterworks. Picture this. After an exceptionally severe frost, a water plug burst and completely flooded Mr. Blythe's house. Obviously, he sued the waterworks company seeking damages for the destruction. But the court had to pause and ask, did the company actually do something wrong? To answer this, the ruling established something totally revolutionary. The judge defined negligence as failing to do something which a reasonable person would do or doing something a reasonable person would not do. The waterworks company had installed pipes that withstood normal, historical frosts. They simply couldn't be expected to predict a completely unprecedented freak freeze. Because they acted as a reasonably prudent entity would under normal circumstances, they weren't negligent. And with that single ruling, the objective standard of the reasonable person was officially born.
Let's move to and see how this builds across the decades. Charting a course from 1856 right up to 2015, we can actually watch how courts have constantly had to refine what this hypothetical reasonable person looks like as society gets more complex. We're going to trace this exact path today to see how the law responds to changing times, shifting technologies, and evolving social values.
Moving on to Section 2, measuring foreseeable risk. This is all about calculating the odds.
Because, once we have our reasonable person, we have to figure out how they actually calculate danger out in the real world. Courts use this delicate balancing act to measure if a risk was obvious enough to prevent. They look at 3 main things: the likelihood of harm, the magnitude of that harm, and the practicality of taking precautions. Take the 1951 case of Bolton and Stone. A woman standing outside her house was suddenly hit by a cricket ball that was struck entirely out of a nearby cricket ground. Now, a cricket ball had only been hit out of that ground 6 times in over 30 years, so the likelihood of harm? Incredibly low. To absolutely prevent it, the club would have had to build a wildly impractical giant fence or just stop playing altogether. The court ruled the club wasn't negligent. A reasonable person just doesn't take vastly expensive precautions against fantastic probabilities. But compare that to the 1943 Glasgow Corporation case. A massive, super heavy tea urn full of boiling water was being carried through a narrow public tea room corridor that the manager had allowed to fill with waiting children. Well, the urn slipped and tragically several children were severely scalded. Here, the court established that a reasonable person would foresee that carrying a heavy, boiling urn right through a dense crowd of kids carries a massive magnitude of potential harm. It requires a much higher level of care, like simply clearing the hallway first. So it's really all about balancing those odds and consequences.
Which brings us to Section 3, learners, children, and exceptions. How does the law adapt the standard?
I love this part, because we get to see how the law handles everyday people with totally different experience levels. One of my favorite legal quirks is found in the 1971 case Nettleship versus Weston. A learner driver panicked, crashed into a lamppost, and injured her instructor. Now you might think, well, she's a learner, she shouldn't be judged harshly, she was doing her incompetent best, right? Wrong. The court ruled that she must be held to the standard of a competent, experienced driver. Why? Well, the court recognized a really crucial public policy element here. Drivers are required to have insurance. If the standard were somehow lowered for learners, injured victims on the road might go uncompensated simply because they had the bad luck to be hit by a beginner. So to protect the public, the standard remains universally high for everyone engaging in adult activities like driving. However, compare this to the 1997 case of Mullen versus Richards. Two 15-year-old girls were playfully sword fighting with plastic rulers. A piece of plastic snapped, flew up, and blinded one of the girls in one eye. Was the other girl held to the standard of reasonable adult foresight? Absolutely not. The court ruled she should be judged strictly against the standard of an ordinary, reasonable 15-year-old. The fascinating nuance here is that adult inexperience doesn't lower the standard for public safety reasons, but chronological age fundamentally changes the standard because children just naturally have a different capacity for foreseeing danger.
Okay, on to Section 4, the professional standard. What happens when experts err?
When we look at experts, we see exactly how strict the law can be. The 1988 case of Wilshire involved a premature baby who was tragically given way too much oxygen by a junior doctor, which sadly led to blindness. The defense argued, pretty understandably, that the doctor was just a junior. They were working incredibly long hours, doing the absolute best they could under immense pressure. And this brilliantly illustrates the court's boundary, because they firmly stated that the standard of care is tied to the post, not the person. If you step up to fill the shoes of a specialized neonatal doctor, you are judged by the standard of a competent, specialized neonatal doctor. Your personal lack of experience or your fatigue, it's entirely irrelevant. The law firmly dictates that a patient's right to competent care comes first, regardless of the individual doctor's resume.
But here's a question. How do courts actually know what a competent professional looks like? I mean, judges are legal experts. They're not medical doctors. Enter the famous 1957 Bolam case. Mr. Bolam underwent electroconvulsive therapy and sustained severe pelvic fractures because he wasn't given muscle relaxants or physically restrained. At the time, some doctors routinely used relaxants, others strictly avoided them, fearing the relaxants themselves carried fatal risks. The court had to decide who was right. To do this, they established the Bolam test. It essentially states that a professional is not negligent if they act in accordance with a practice accepted by a responsible body of medical men skilled in that particular art. Basically, if a respectable group of your peers says, yep, we would have done it that way too, you are legally protected, even if another group of experts strongly disagrees. This ushered in this deeply paternalistic era of doctor knows best, where the medical profession was essentially allowed to set its own legal standard of care, completely free from the courts second-guessing their clinical judgment.
And finally, Section 5, the shift to informed consent. Let's talk about the patient's power.
Now, what's really interesting about this next part is that everything we just learned about professionals recently underwent a massive paradigm shift. It completely changed the power dynamics between doctors and patients. Under that old Bolam test of 1957 we just talked about, doctors essentially decided what risks they should disclose to a patient. If other doctors agreed that a certain risk was too small or maybe too complex to mention, withholding that info wasn't negligent. But then came the Montgomery case in 2015. A diabetic mother with a larger-than-average baby was not informed by her doctor about a 9 to 10% risk of shoulder dystocia, which is a really severe complication during natural birth. The doctor openly admitted she didn't mention this risk because she felt it would unnecessarily scare the mother into requesting a C-section, which the doctor believed was not in her best interest. Tragically, complications did occur, and the baby suffered severe injuries. The court completely upended the old standard here. Montgomery ruled that the Bolam test no longer applies to advice and consent. A doctor can no longer withhold information just because they think it's for the patient's own good.
The Supreme Court essentially recognized that we no longer live in an era where patients are just passive, uninformed recipients of medical care. The Montgomery ruling powerfully establishes that adult patients of sound mind have the fundamental right to decide which medical risks they are willing to take. The legal standard is no longer, what would a reasonable doctor choose to disclose? The new standard is, would a reasonable patient in this specific situation attach significance to the risk? It is the ultimate legal triumph of patient autonomy over medical paternalism. The power to choose, to be fully informed, and to weigh the risks regarding your own body is now firmly in your hands.
So, the crucial point is that the reasonable person isn't some static, unmoving statue carved in stone back in 1856. They are a constantly evolving reflection of our society's values, our fears, and our expectations. From a freezing water pipe to a flying cricket ball, from a nervous learner driver needing to be insured to a modern patient demanding the fundamental right to choose, the law is constantly adjusting its objective measuring stick. We've literally watched the standard shift from protecting early industries to fiercely empowering individual rights. Which leaves us with one final thought to ponder. As our world rapidly introduces artificial intelligence, incredibly complex algorithms, and entirely unprecedented new risks, as society continues to evolve, who will the reasonable person be tomorrow? Thanks so much for joining me on this explainer, and I'll see you next time.